All rise. Vous vous levez. The International Criminal Court is now in session. L'audience de la Cour pénale internationale est ouverte. Please be seated. Vous asseoir.
Okay. Bonjour à tous. Je vous souhaite la bienvenue et sans tarder, je vais m'adresser à monsieur le greffier d'audience pour lui demander d'annoncer l'affaire. Monsieur le greffier.
Good morning, Mr. President, Your Honors. Situation in the Central African Republic in the case of the prosecutor versus Jean-Pierre Bemba Gombo, case number ICC 0105-0108, and for the record, we're in open session.
Merci beaucoup, monsieur le greffier. Je vais demander maintenant aux parties de se présenter, en commençant par le bureau du procureur. Mais avant cela, j'aimerais demander à tout le monde de parler lentement et de marquer des pauses avant de répondre aux questions, afin de permettre aux interprètes de faire leur travail. Puis-je demander maintenant aux représentants du bureau du procureur de bien vouloir se présenter et de présenter les membres de son équipe.
Good morning, Mr. President, Your Honors. It's Fabrizio Guariglia, Director of Prosecutions, and appearing with me today are Ms. Helen Brady, Senior Appeals Counsel, Ms. Priya Narayanan, Appeals Counsel, Ms. Nivida Thiru, Appeals Counsel, and Ms. Sylvie Vidigne, our case manager. Thank you.
Merci beaucoup, Monsieur le procureur. Je vais maintenant m'adresser aux avocats de M. Bemba. Vous avez remarqué, conformément à votre vœu, je ne dis pas avocat de la défense, parce que M. Jean-Pierre Bemba Gombo a été acquitté. Alors, je m'adresse à vous en tant qu'avocat de M. Jean-Pierre Bemba. C'est bien ça. Alors, puis-je vous demander de vous présenter, ainsi que de présenter les membres de votre équipe.
Well, good morning, Your Honour, and good morning to some familiar and friendly faces in the courtroom. Of course, your faces are not familiar to us. This is the first time we've had the honour and the privilege to appear in front of you, and may we say how welcome a privilege it is, and we're grateful for you for affording us this opportunity. My name's Peter Haynes. Sitting to my right is Kate Gibson, my co-counsel, and behind me, Cecile Lecole, our case manager. You will, of course, have noted that our client, Mr. Bemba, is not present. He doesn't, of course, have the happiest memories of his time here in The Hague or in Scheveningen and prefers not to attend. But you can be assured that we act upon his instructions at all times, and we're in regular contact with him.
Merci beaucoup, Maître Haynes. Enfin, j'aimerais me présenter moi-même, ainsi que mes collègues. Je m'appelle Antoine Kessambe Mindoa et je suis juge-président de la Chambre préliminaire 2 de la Cour. À ma droite se trouve Madame la juge Tomoko Akane et à ma gauche, Monsieur le juge Rosario Salvatore Aitala. Tout d'abord, je crois qu'il est utile de clarifier la nature de cette audience. Celle-ci s'inscrit dans le cadre de la procédure liée à la demande d'indemnisation que M. Bemba a soumis le 7 mars 2019 à cette Chambre sur la base de l'article 85 du Statut de Rome. Le 14 mars 2019, la Chambre a décidé de la tenue de cette audience afin que les parties puissent présenter oralement leurs observations concernant la demande d'indemnisation. Je tiens à rappeler que les parties sont invitées à ne pas simplement répéter le contenu de leurs écritures. Personnellement d'ailleurs, je trouve que les documents que vous avez soumis sont excellents quant à la forme et quant au fond. Je vais donc donner la parole à chacune des parties en vous priant d'être clair et concis dans vos interventions qui ne devraient pas dépasser la durée de 30 minutes afin que le temps de parole puisse être réparti équitablement et qu'il reste assez de temps pour d'éventuelles questions. Maître Haynes, vous avez à présent la parole.
Your Honour, thank you very much. And as a matter of courtesy, I notice also that the representatives of the registry are here in court in due course. I'm sure they will introduce themselves. This is a case in which you're going to be sailing into uncharted waters. This is new territory. Our analysis is that Mr. Bemba may very well be the first and only person whose assets have been frozen by order of an international criminal tribunal or court. He is certainly the only person whose assets have been frozen who was subsequently acquitted. So therefore, Your Honours, you will be making the law about this in this case. There's not much in the jurisprudence of this court or other tribunals to assist you. You'll have regard, of course, to what the judges thought in Ngajolo, but that's merely informative. It's not binding upon you, and given the vast discrepancies between the facts of the cases, it's barely persuasive. More stridently, I say that the views of the minority of the appeals chamber who acquitted Mr. Bemba are completely irrelevant, as are the views of the judges of the trial chamber who convicted him at first instance. The starting point factually for you is that Mr. Bemba was wrongly convicted. Now, I'm not about to submit that every person whose conviction is reversed on appeal is the victim of a miscarriage of justice. But this was an exceptional case, and in this case, Mr. Bemba's wrongful conviction, we submit, does equate to a miscarriage of justice. The manner of his conviction, both procedurally and in terms of the initial judgment passed upon him, was stark and shocking. The language used by the three seasoned and experienced judges who overturned his conviction is unprecedented. They were quite simply flabbergasted by what they saw in the judgment, the manipulation of the evidence, and the failure properly to apply central and essential principles such as the burden and standard of proof. They were explicit. They had to intervene to prevent a miscarriage of justice. Theirs are the only relevant views for you to consider in our submission. To do otherwise would be to fail to respect a verdict of this court. Now, an acquittal on appeal does not prevent a finding that there has been a miscarriage of justice. The reversal of the conviction does no more than prevent the miscarriage of justice from continuing further. Touching on what you've already said, on Monday evening we received something like 80 pages of filings from the parties opposite. We've had a limited time to digest them, and we anticipate everybody is going to want to say a few things today. I am going to limit myself to 20 or 30 minutes of your time, and I can't deal in that time with every submission made by the Office of the Prosecutor and the Registry. You have already received our request for leave to reply in writing, and I hope you will consider it on its merits favourably. Today, I'm just going to outline a few bullet points for you. Now let's get real. It's 11 years since Mr. Bemba's arrest and almost a year since his release. Obviously, being at liberty makes a substantial difference to his quality of life, but in terms of his access to his property, really not very much has altered. He has no bank account to which he has access. He cannot withdraw cash from the bank at the cash point machine, nor, amazingly, can his wife. He can't open a bank account. His air freight business has been destroyed. His homes in the Democratic Republic of Congo are occupied by squatters and have been ransacked. His motor vehicles are quite literally being eaten by rats in a compound in Lisbon. And his Boeing 727 aeroplane sits on the tarmac at Faro Airport in precisely the same position from which he disembarked it in 2007. Now, how did this situation arise? Well, in May of 2008, the Office of the Prosecutor seized pre-trial chamber 3, with applications for RFAs in 3 states. Those requests are apparently so secret that even to this day, we, Mr. Bemba's lawyers, are not allowed to see them. But we can work out in what terms they were cast. And there are 2 features of those requests that are of particular note. Firstly, they were indiscriminate. They sought the tracing, seizure, and freezing of absolutely every asset in each jurisdiction. And secondly, they did not only target Mr. Bemba. They also targeted members of his family, including his wife and his children. Now, in 2008, the age range of Jean-Pierre Bemba's children was 10 to 17. Mr. Moreno Ocampo and his staff would have been well aware of the ages and identities of Mr. Bemba's children. What was the possible purpose of asking a court to seize and freeze the assets of a 10-year-old boy or 2 twin 12-year-old girls? It cannot possibly have had anything to do with securing assets to provide reparations to victims in the future. It can only have been to cause hurt, distress, and embarrassment. Seeking to target the property of children in these applications was, in our submission, spiteful and malicious. Now, we disagree with the prosecution that proof of malice or malafides or malfeasance is a necessary prerequisite for a successful claim under Article 85 of the statute. There were some very clever lawyers who drafted the Rome Statute. They were well aware of phrases like malafides, malfeasance, and malicious prosecution, and if they'd wanted to include them in Article 85, they would have done. And they didn't. And it would be wrong for you to import notions such as that into a construction of that article now. But if you wanted evidence of malice, there it is at the very inception of these proceedings. And it has continued right through to this day. You'll find it in the prosecutor's statement of June the 13th, 2018, when the last thing on earth she could bring herself to do was express regret for the fact that Mr. Bemba had spent 10 years in custody, which she should have done. You'll find it in the fact that Mr. Bemba's wife still cannot access her property or bank accounts, and that nobody in this room will lift a finger to help her do that. Malice and bad faith suffused this prosecution from start to finish. A malice born of personal and institutionalized enmity towards Mr. Bemba and his family. We didn't raise it in our initial filing because we don't believe it's part of the necessary means of proof. But now that it's been raised over there, we answer it. These aren't the only examples. The greatest of them all has probably slipped under the radar, and that's the planes at Njili Airport in Kinshasa. The prosecution knew about them. Of course it did. It has all the financial investigative tools, as the registry has submitted. It worked hand in hand with authorities in the DRC throughout this case. And let's be honest, Mr. Bemba's sources of wealth and income were hardly secret. The registry knew about them. How could it not? It was, as it submits, in regular contact with the states concerning the freezing of property. This wasn't the first Congolese accused before the International Criminal Court. So what happened to the 6 aeroplanes at Njili Airport that belonged to Mr. Bemba? Shortly after the issuance of the RFAs, they were moved to one side of the airfield on the instructions of representatives of MONUSCO, the peacekeeping force in the Congo. And a few days later, in the face of objection by Mr. Bemba's lawyer, they were simply destroyed, cut to pieces. That, at least, is how I translate the word découpé in the relevant witness statement. Now, how was that ever going to help the victims? How was that going to protect a fund to provide reparations? Assets valued at 33 million euros just cut up. Mr. Bemba's principal income stream turned off. Now, had this all been a terrible mistake, you might have expected a representative of the Office of the Prosecutor or the Registry to communicate it to Mr. Bemba's lawyers, or to him directly even, to go to him and say, something awful has happened. The authorities in the Congo misunderstood why we were asking them to seize and freeze your assets. But nothing of that sort happened. Nobody went to Mr. Bemba and said, you've just lost your whole income stream. 33 million euros worth of planes have just been cut to pieces. No, they didn't do that. because, as we say in English, the proof of the pudding is in the eating, which is a roundabout way of saying people intend the consequences of their actions. The cutting up of Mr. Bemba's planes was not a mistake. This was about cutting him down to size. This was about saying, we've got you now, and we can do whatever we want to you and your family. Now, the registry purport to deal with this incident in their response. They say that this was not done by the court. Cited, redacted, 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 redacted. Well, sorry, but no. This is a system of public and open justice. Either that is disclosed and we get to make submissions about it, or you ignore it, whatever it is. The second registry submission that Mr. Bemba could have and should have applied to discharge the freezing orders once he became suspicious that they were being mismanaged is equally naive. What would have been the possible point of that? He could have gone before Judge Steiner and said, can you please give me back the cut-up pieces of my aeroplanes? Now, while I'm there, I want to say something about burdens and standards of proof and evidence. Mr. Bemba brings this claim, and of course he therefore bears the burden of proving it. But he doesn't have to convince you of anything. This is a civil claim. The appropriate burden of proof is on a balance of probabilities. And he proves that case on evidence. And he's gone to the trouble of providing you with some. 3 witness statements, an expert's report, and various exhibits. We filed this claim in March, and everybody asked for a little extra time, and you granted it, so that they could deal not just with the legal issues, but the factual issues that were raised in this case. 2 months is perfectly enough time to deal with factual issues that have been raised, even enough time to garner, collate, and submit some evidence if you want to contradict something Mr. Bemba is asserting. But nobody has chosen to do that. No investigator, Portuguese police officer, representative of MINUSCO, or the like, has been brought before you in the form of a witness statement to contradict anything that Mr. Bemba's evidence lays out for you. You have no reason or basis to disbelieve any of the claimant's evidence, and you are therefore bound in our submission to make findings in line with the evidence that Mr. Bemba has provided you with. Pleadings are of some use in that they crystallize the issues that are live in the case. And we submit to you that any sensible analysis of the pleadings or filings in this case reveal that there isn't much in dispute. These are the things that are not in dispute. 1, Mr. Bemba's assets were decimated. I'm not concerned with the financial loss. They were destroyed. They were decimated. We all agree that. 2, the destruction of the property resulted from the requests for assistance issued by the ICC. 3, the pretrial chamber issued the request for assistance at the request of the prosecution. 4, the requests for assistance were framed in the broadest of terms. 5, the destruction of somebody's personal property is a breach of a fundamental human right. 6, the ICC is an international institution that has a legal personality and it is not immune from civil claims. And 7, the ICC has the power to provide persons affected by its decisions with a remedy. None of that's in dispute. Plenty of time to dispute it if they wanted to. Indeed, leaving aside the issue of whether Mr. Bemba has established a miscarriage of justice, the only thing that's really in dispute in this case, the only moving parts, is how much financial loss was caused to Mr. Bemba and who and in what proportion should be obliged to repay him for it. Now, I want to say something about freezing orders because they really are at the heart of this case. And I want to preface it all by perhaps giving a little evidence. You see, I've been a lawyer for 35 years. I've practiced in civil courts and criminal courts, domestic courts and international courts. And I cannot underline for you sufficiently how serious a freezing order is. How seriously courts who are being asked to make them regard those applications, and how serious the impact of those orders are upon those who are affected by them. It breaches their fundamental human right to property. It stops them living their lives. It stops them acting commercially. It's not by coincidence that freezing orders are referred to as one of the law's nuclear weapons. Nor is it a coincidence that despite having had many wealthy accused before it, the ICTY never froze anybody's assets. The ICTR never froze anybody's assets. And the Special Court for Sierra Leone, having the fabulously wealthy Charles Taylor before it, didn't freeze his assets either. Those courts knew that these are not orders to be played with, and that they had the self-effacement to acknowledge their own shortcomings and ability to manage properly such orders. Now, I hate to say this, but I sense in the submissions of the prosecution and the registry a lack of apprehension of that fact. They don't realise how serious these orders are, and they don't realise how serious what has been done is in this case. Now, we've set out before you a compendious review of the domestic and international practice in relation to freezing orders. And we did that not because we suggest that the ICC is subject to European Union regulations. Of course it isn't. But we did that to illustrate that the development of the law on freezing orders is consistent worldwide. And you can derive 3 principles from it, we submit. 1, when you take possession of somebody else's property, you assume responsibility to look after it. And that responsibility is multifarious and serious. 2, you cannot delegate that responsibility to a third party, even if they effect the seizure or freezing, whether they're within your jurisdiction or another. And 3, if it all goes wrong, or your action is misfounded, you, as the person who asked for the order, have to indemnify the person whose assets were frozen. That's why we set those things out. And the ICC, as an institution with a legal personality who asked for those orders, is in no different position to anybody else. This all went badly wrong. The temerity of the registry's submissions in this regard really beg a belief. They suggest that it was for Mr. Bemba, appreciating that his assets were being mismanaged, to go before Trial Chamber 3 and ask them to lift the freezing orders. Well, let's leave aside for 1 minute the fantastic possibility that Judge Steiner would ever have lifted a freezing order in relation to Mr. Bemba's property. But place that in the context of accepted international protocol. That is to put it quite the wrong way round. And the real temerity of that submission is that within a very few years of the making of these freezing orders, the registry was painfully aware of how badly wrong it was all going. They were submitting internal reports saying, there will be no money left for reparations. We will not be able to advance funds to Mr. Bemba's lawyers. Where, we say, was their application to Trial Chamber 3 to discharge the freezing orders? Where were they accepting the responsibility of going before the court and saying, before this goes completely belly up, we need to review what we're doing? Now, one last thing before I conclude, and that is another area in which we suggest our submissions have been misrepresented or maybe just misunderstood. Mr. Bemba's claims in relation to his destroyed property are pleaded in the alternative. The claim for the destruction of his property does not depend upon a finding that there has been a miscarriage of justice. That claim could well succeed, or could well have succeeded, even in the event that his trial had been perfectly regular, or in the event his conviction had been upheld on appeal, because it depends upon the actions of the court in failing to look after the property it seized. These claims were simply amalgamated as a means of expedience. Rather than wait for whatever period of time to amass the evidence in relation to a claim for his destroyed property, he has compiled it in with his Article 85 claim so that the matter is expeditiously before the same chamber. Two things to conclude. One, I want to say a few words in defence of Mr. Bemba's position in bringing this claim. The commentary surrounding this case, in our view, has been unfairly critical of Mr. Bemba. But people suggest that it's an act of revenge, or that he's trying to bankrupt the court, or that his claim is in some way disproportionate. But that ignores the reality. This happened. His property has been destroyed. It was a result of the request for assistance issued by this court. He would have preferred to walk out of prison on June the 8th last year and been handed the reins to a thriving air freight business, and been handed the keys to his houses and told where he could pick his cars up, and be given a wallet full of credit cards that he'd have got out and spent in a restaurant. He still can't do any of those things. And the effect of his claim is only to ask you to put him back in the situation he was in May 2008. It is no more and no less than that. If you do award him any damages for his incarceration, he will give that to victims in the Central African Republic. Now, as you know, we would have preferred to come and talk to you about this case really when all the pleadings were closed. We would have preferred, and I don't think we're necessarily controversial in this, that you received some input from the states concerned. But here we are. We're talking to you really midway through the filings in the case. So we want to make some concrete suggestions as to the roadmap forward. Don't be under an illusion that a finding that this claim fails because Article 85 hasn't been satisfied will be the end of anything. It won't. And don't be under any illusion that a finding that the states and only the states are responsible for the losses occasioned to Mr. Bemba will bring an end to anything. It won't. Indeed, such a finding would be scandalous and, in our view, contrary to the rules of natural justice. Mr. Bemba's losses are increasing daily. Now, what usually happens, and again, forgive me if I'm trespassing into the area of evidence in cases or claims of this sort, is that at about this stage, a court would refer the matter to what's generally called ADR, alternate dispute resolution. And we're perfectly ready, on Mr. Bemba's behalf, to engage in that sort of exercise in any form, whether it's through referral of the matter to some formal arbitration authority, or by simply ordering the parties, which you perfectly well can do, to sit around a table somewhere in this building. That, we submit, would be a constructive and sensible way forward, leading to an expeditious and practical resolution of the matters referred to herein. I'll finish where I started. This happened to Mr. Bemba. Hopefully lessons have been learned and it won't happen again. But his situation needs to be repaired, and this sorry chapter of the court's history needs to be closed. Thank you very much.
Merci beaucoup, Maître Haynes, pour votre brillante présentation. À présent, avant de passer la parole au bureau du procureur, je voudrais faire quelque chose. Je vois dans la salle, il y a encore 6 personnes. Normalement, les débats de ce matin, c'est par rapport aux avocats de M. Jean-Pierre Bemba et au bureau du procureur. Mais comme l'a suggéré tout à l'heure Maître Haynes, je pense qu'il est nécessaire que le bureau du greffier puisse se présenter, parce que je vois qu'il y a M. Marc Dubuisson, et puis je vois encore d'autres personnes. Alors, je vais d'abord donner la parole à M. Marc Dubuisson pour se présenter son équipe, et me dire aussi si les 3 autres personnes sont de son équipe. Merci.
Je vous remercie, Monsieur le Président, Madame et Monsieur le juge. Effectivement, sur le banc du greffe avec moi aujourd'hui, il y a Marie Mathieu, qui est juriste au bureau des affaires juridiques du greffe, Nathalie Wagner, qui est juriste à la division des services judiciaires. Ensuite, à l'arrière, il y a Vera Chi Wang, qui est juriste à la division des opérations extérieures. Et enfin, Elisabeth Bourlar-Smith et Rufina Kutsniarova, qui sont des juristes à l'unité pour les relations extérieures et la coopération avec les États. Et moi-même, donc Marc Dubuisson, je suis ici pour représenter le greffier Peter Lewis.
Merci beaucoup d'être venu. Donc je vois que les 6 personnes que vous êtes du bureau donc, du greffier. Merci beaucoup, merci. À présent, je voudrais donner la parole au représentant du bureau du procureur.
Thank you so much, Your Honors. I will make some introductory remarks, and then my colleague, Ms. Narayanan, will address the main arguments advanced by Mr. Bemba in his claim for compensation. Before I do that, Your Honors, we received yesterday at 6 o'clock in the evening Mr. Bemba's request for a reply. We do oppose the request for a reply. We think that this particular issue has been fully briefed. You have received voluminous submissions from Mr. Bemba, as well as his opportunity to make comprehensive arguments in this hearing. We will provide further reasons in writing as to why we think that the test for a reply to be granted has not been made out. But just for the purposes of the Chamber's knowledge, we will oppose that particular request. Your Honors, in relation to the claim, the prosecutor's position, as you know from our documents, is clear. Mr. Bemba has not shown that he deserves to be compensated by this court. His request does not meet the high threshold under Article 85.3 of the statute, namely a grave and manifest miscarriage of justice. In fact, Mr. Bemba's claim falls manifestly short of the legal standard, and should accordingly be dismissed. Let me first give you a brief recap of this case, which you may contrast with the one provided to you by Mr. Haynes. Mr. Bemba was charged as a superior under Article 28 of the statute with war crimes and crimes against humanity. In 2009, the pretrial chamber unanimously confirmed those charges, and in 2016, the trial chamber unanimously convicted Mr. Bemba and sentenced him. In 2008, 8 June to be more precise, the appeals chamber, by majority, acquitted Mr. Bemba of crimes against humanity and war crimes. 2 other judges of the appeals chamber dissented, and in a comprehensive opinion explained why they would have upheld Mr. Bemba's convictions on appeal. Notwithstanding, once he was acquitted, the outcome of this case against Mr. Bemba was final. But Mr. Bemba's engagement with the court doesn't finish there. There is, as the chamber is surely aware of, a second case. While Mr. Bemba was detained for the charges of crimes against humanity and war crimes, he was alleged and found to have committed offenses against administration of justice, together with his then leading counsel, another member of his defense team. In 2016, Trial Chamber 7 convicted Mr. Bemba of Article 70 offenses, and in 2018, the appeals chamber, in a different composition, unanimously confirmed his convictions for soliciting the giving of false testimony, Article 71A of the statute, and for corrupting witnesses under Article 71C. Those convictions are final, although Mr. Bemba has launched a second sentencing appeal in that case. Your Honors, Mr. Bemba has brought this compensation claim 9 months after he was acquitted in the main case. He asks to be compensated in the sum of 68.6 million euros, an unprecedented amount, and suggests that this sum is owed to him in several ways. You have heard Mr. Haynes. I will still give you our understanding of the different categories of claims that he has made. Some of this money is allegedly owed to him for his detention, some as aggravated damages, some as legal costs, and some in relation to purported damage to his property, a particular area in which my colleague Mr. Haynes seems to have placed particular emphasis during the hearing. But this discussion, which takes up almost half of the allocated 60 pages of the request, is actually beside the point. It cannot avoid the central question at the core of all compensation claims. Has Mr. Bemba established a grave and manifest miscarriage of justice in the sense of Article 85.3, such that he should be compensated by this court? The answer, Your Honors, is a resounding no. Mr. Bemba has not met his burden to show that he has suffered a grave and manifest miscarriage of justice. That was already clear on his written submissions. The belated attempt made in this hearing to suddenly present a mala fides case for compensation doesn't change that. If Your Honors are convinced, as we are, that the conditions of Article 85 are not met, then these proceedings can be brought to a swift end. I have taken note of Mr. Haynes' warnings that this will continue after that. And of course, Mr. Bemba is free to resort to whatever remedy he considers appropriate. But the fact is that Article 85 proceedings should be terminated, will be closed, and there will be no more legal recourse within the court's legal process for Mr. Bemba. Your Honor's compensation proceedings were always meant to be limited in scope and exceptional in nature. Article 88 was carefully carved out when the Rome Statute was negotiated. And to respect the compromise achieved in Rome by very intelligent lawyers, indeed, certain fundamental principles must continue to govern compensation proceedings before this court. First, compensation proceedings involve a two-step process. The applicant must first convince a panel of judges whether the compensation chamber, in this case you, Your Honors, or a previously seized chamber, the trial chamber or the appeals chamber in this case, of an Article 85 violation. And he must be able to affirmatively point at the relevant parts of the record that establish that violation. Further, Your Honors, for a claim brought under Article 85.3 to succeed, the applicant must show the existence of a grave and manifest miscarriage of justice. Mr. Bemba's claims fails at this first hurdle. There are simply no such findings on the record, nor has he otherwise shown that this chamber should make those findings at this stage. Second, and this is unique to Mr. Bemba's claim, compensation proceedings are not a second appeal. Yet, Mr. Bemba repeats in his written submissions several arguments that he has previously voiced unsuccessfully at trial, many of these in a December 2014 abuse of process motion that was rejected. Those arguments were raised again on appeal by Mr. Bemba. The majority judges simply did not address them. The dissenting judges on appeal actively rejected those arguments. The outcome of this case is final. Arguments from those proceedings are no longer relevant. Principles of certainty, efficiency require this approach. If not, when will this end? Third, Your Honors, these proceedings are Article 85 compensation proceedings governed by the Rome Statute. They are not proceedings to determine claims of negligence, tort, or otherwise entertain Mr. Bemba's private claims. These aspects of Mr. Bemba's claim fall manifestly outside the scope of Article 85 and therefore of these proceedings, and outside the jurisdiction of this chamber. They must accordingly be dismissed. Your Honors, my colleague Mr. Narayanan will address now some of the key arguments advanced by Mr. Bemba and explain why his claim cannot succeed on the basis of those arguments. Thank you.
Merci beaucoup, Monsieur le Procureur.
Good morning, Your Honours. My name is Priya Narayanan, and in our remaining time, I will address Your Honours on why Mr. Bemba's claim falls so manifestly short of the Article 85 legal standard. We have noted your instructions, Your Honours, and so we will focus only on those key issues which in our view demonstrate the limitations of Mr. Bemba's claim. And I can assure you that we will not take too long. Our written submission is our comprehensive response to all the issues that Mr. Bemba has raised so far. And also, in light of Mr. Bemba's submissions today, we will invite you, Your Honours, to look closely at the record in making your decision. But first, what is the legal standard for this compensation claim? And has Mr. Bemba met it? As Mr. Warilia has just said, the legal threshold is a high one, and Mr. Bemba has not met his burden. But allow me to turn first to this legal standard under Article 85.3, a grave and manifest miscarriage of justice. And Your Honours, this is not new territory or uncharted waters. This is the court's law. To explain this, I will make 4 points. First, obviously, Your Honours, the terms grave and manifest qualify the phrase miscarriage of justice. So since Mr. Bemba has chosen this provision as the basis for his claim, he must show not only that he suffered a miscarriage of justice, but that it is grave and manifest. So if one were to explain this differently, and as the Oxford English Dictionary says, other words for grave are egregious and critical, and the term manifest means obvious or unmistakable. Second, the Ungojolo Chamber, and this is the correct standard in our view, interpreted this provision to mean a certain and undeniable miscarriage of justice. it should result in a clear violation of the applicant's fundamental rights, which caused serious harm. And I'd like to refer you to the Ungujolo compensation decision, paragraph 45. And this interpretation also follows the concerted choice of the drafters of the Rome Statute. As you know, Your Honours, Article 85.3 was born out of a resolve not to compensate a person when he or she is acquitted, but rather compensation under this article was limited to those exceptional circumstances that a chamber finds will warrant it. The phrase exceptional circumstances underlines the drafter's intention to limit liability in the case of acquittals. It does not imply just a wish that cases of miscarriages of justice should be few and far between, as Mr. Bemba seems to suggest in his claim. So in other words, awarding compensation upon acquittals was meant to be exceptional. Third, again, as the Ungujolo Chamber has said, the Article 85.3 standard should be viewed through the lens of mala fide actions, whether wrongful prosecutions or similarly wrongful judicial decisions. And Your Honours, with respect, the clever lawyers who drafted the Rome Statute meant exactly that. Some of them sit beside me, and there are, of course, others in this institution. So clearly, not every error, or even one leading to an acquittal, is enough. And even if found, not every miscarriage of justice is a grave or manifest one. Fourth, Article 85 as a statutory compensation scheme is exhaustive. It is already consistent with international human rights standards, and in fact, Article 85.3 goes beyond these standards. Allow me now to turn to the specifics of Mr. Bemba's claim under Article 85.3. At the outset, we note that Mr. Bemba's submissions today on Article 85 are somewhat different from his written claim. But nonetheless, we will address those key issues in the claim. In a nutshell, Your Honours, Mr. Bemba's claim is simply not what Article 85.3 is meant for the following three reasons. First, some of the issues that Mr. Bemba brings are insignificant to Article 85. Indeed, Your Honours, some may even seem trivial. As his very first allegation, his lead allegation at the heart of his complaint, he asks you to consider his contention that several footnotes in the trial judgment are inaccurate. Your Honours, these Article 85 proceedings before you have a certain gravitas. They were designed to provide for genuine miscarriages of justice, not what Mr. Bemba perceives as anomalies in footnotes. But still, on this point, Mr. Bemba has never fully identified which 84 footnotes he takes issue with among the over 2,000 footnotes in the trial judgment. But that said, Your Honours, we have looked more closely at the three examples that Mr. Bemba gives in his claim, and we have compared them to the official transcripts. Two of the examples that Mr. Bemba gives to fault the trial chamber are actually the opposite. They confirm that the trial chamber was correct in its references and that the error seems to lie with Mr. Bemba. And the third example is nothing more than a typo. It could happen to anyone, perhaps even to Mr. Bemba or his counsel. Likewise, another aspect of his complaint focuses on his counsel's disagreement with the presiding judge at trial some 8 years ago, that one question asked of one witness in the course of trial was leading in nature. Let alone a grave and manifest miscarriage of justice, Your Honours, these aspects do not even rise to the level of showing an error. Second, Mr. Bemba uses these compensation proceedings as a second appeal. Many of the arguments he now raises, whether it relates to how the trial was run, or how witnesses were treated, or how the prosecution and the trial chamber approached the Article 70 investigations into Mr. Bemba's criminal conduct, or even how the legal representative of victims was allowed to participate in the trial, these are all issues which the trial chamber heard, comprehensively addressed, and rejected. Many of these issues were raised in Mr. Bemba's December 2014 abuse of process motion. They were heard and rejected. There are also arguments which the dissenting judges on appeal heard, comprehensively addressed, and rejected. Now, the majority judges on appeal did not consider them necessary to entertain, but on this point, we have the dissenting judges' views that the majority's opinion was not necessarily inconsistent with their own. And I'd like to refer you to the dissenting opinion to the Bemba appeal judgment, paragraph 1. And we must note, Your Honours, at this point, that Article 74(5) provides that all views, all judicial opinions are part of the judgment, whether they're in the minority or in the majority. But yet, at this very late stage, Mr. Bemba asks you to consider or reconsider these arguments again for the third time in these proceedings. This cannot be. Compensation proceedings are not proceedings of last resort, which Mr. Bemba or any other applicant tries when he has tried all else and failed. Rather, the remedy is one of exceptional resort, limited only to those deserving complaints which genuinely meet the Article 85 test. Mr. Bemba's claim is not one of those. Third, Mr. Bemba's allegations against the prosecution are simply not founded. At the outset, we note that Mr. Bemba brings only one allegation against the prosecution as an alleged miscarriage of justice under Article 85, namely whether the prosecution investigated the Bemba case properly. But on its face, this complaint does not relate to how the investigations were conducted, but rather it relates to the change in the mode of liability from Article 25(3)(a) to Article 28 at confirmation. But, Your Honours, this is exactly what the confirmation process is for. Clearly, Mr. Bemba himself did not consider the issue of supposed investigative bias important enough before these proceedings. He did not complain about it in his earlier abuse of process motion or even on his appeal. So this is, in a sense, the first we're hearing of this. And as the Ngujolo Chamber has already said, compensation proceedings are not the place to scrutinize the prosecution's investigations under a microscope or with the benefit of hindsight in a rear-view mirror. Whatever the nature of the prosecution's investigation, it simply cannot ensure a particular outcome. The prosecution investigates to the best of its ability. It has no obligation of, it has an obligation of means, but not an obligation of result. Moving on, of the two other claims that Mr. Bemba makes against the prosecution, namely that the losses he claims in relation to the plane can be attributed to the prosecution in some way, and regarding the prosecutor's public statement after the Bemba appeal judgment, Your Honours will need to consider them only if you were to first find that there has been a miscarriage of justice. Otherwise, these arguments, which are made to support his claim for consequential loss or damages, are irrelevant and may simply be dismissed. In any event, neither claim can be made out. On whether the prosecution's conduct caused Mr. Bemba to suffer losses with respect to the plane parked in Faro Airport in Portugal, Your Honours, any question of the prosecution's conduct in this regard, and whether it had the keys and documents to the plane, is beside the point. As the record shows, Mr. Bemba had the plane documents and he could access the plane keys otherwise so as to move and sell his plane. We do not know why Mr. Bemba did not do so. Answers to any questions on the keys, documents, or even the value of the plane all lie in the record before you, Your Honours. And we trust that this explains this issue. All the other submissions that my learned friend has made this morning on the RFAs and the freezing orders were not spelled out in the initial claim as any sort of miscarriage of justice, so we will not address them at this stage. On the prosecutor's statement after the Bemba appeal judgment, this was entirely appropriate, Your Honours. As the appeals chamber and human rights courts have said, the prosecutor, unlike Mr. Bemba, is not just a party to the proceeding. She has a public information role. Reaching out to the victims and the international community is a critical part of her mandate. And what could be more critical, Your Honours, than trying to explain the outcome of the case to victims, including those who suffered sexual violence? This is what the prosecutor did. And the statement was entirely appropriate. It accepted in clear terms that the outcome of the case was final and that she would respect the appeal judgment. This the prosecutor did. The court cannot also be responsible for social media commentary. Commentators on all sides are independent and they comment in their own right. And finally, Your Honours, you may wish to consider some of the unique features of Mr. Bemba's situation. He was acquitted in the main case, and that outcome is final. But while in detention, he interfered with the integrity of this court's proceedings, and that has been found beyond reasonable doubt. It would run counter to the principles of justice to compensate Mr. Bemba in these circumstances. And Your Honours, you have the discretion to assess that. Your Honours, there may be a day when this court will have to address a bona fide Article 85 claim and assess whether someone should be compensated in the circumstances. But Mr. Bemba's claim is not such a claim. Mr. Bemba's claim falls manifestly short of the legal standard. We would respectfully request you to dismiss Mr. Bemba's claim. Unless Your Honours have any further questions for us, that would conclude our submissions. Thank you.
Merci beaucoup, Madame la procureure. Alors, si je comprends bien, le bureau du procureur a fini pour
Oui.
ce matin, c'est bien ça?
Yes, Your Honours, we have finished. Thank you.
Merci beaucoup. Alors, maintenant nous disposons de quelques minutes encore pour d'éventuelles questions de la Chambre. Pendant que mes collègues réfléchissent, j'ai moi-même, je crois, deux petites questions. Une question pour les avocats de M. Jean-Pierre Bemba. J'allais dire de la défense, mais je ne peux pas prononcer ça. Pour les avocats de M. Jean-Pierre Bemba. Et deux petites questions aussi pour le bureau du procureur. Je vais commencer avec les avocats de M. Jean-Pierre Bemba. Maître Haynes, si j'ai bien compris, vous avez dit que il ne s'agit pas nécessairement d'une demande de la présence de l'intention malicieuse pour qu'il y ait une mauvaise justice. I'm going to speak English, so it's better maybe. If I understand very well, you said that every miscarriage of justice is miscarriage of justice. We don't need any mala fide intention. It seems that it's not the definition of the prosecution. So I would like you to maybe elaborate a little bit on that. If you think that every miscarriage of justice is enough, there is no need of mala fide intention, of malicious intention. Because according to the statute, Article 85, we need grave and manifest miscarriage of justice. That will be my first question. The second question is, you have made a comparison between the ICTY, ICTR, and the Special Tribunal for Sierra Leone proceedings about the seriousness of freezing assets. And you said, in the three tribunals, we never had cases of freezing assets. Maybe, according to me, it's just, you may correct me if I am wrong, maybe it is because that before those tribunals, we don't have reparations proceedings for the victims. That is why the freezing was not requested. So what do you think about that? It is because of the seriousness of the freezing or because of the purpose of freezing assets? Thank you, sir.
I'll deal with the second point first. I was really simply seeking to place this case into an historical context and to place alongside the very, very many authorities we've cited, both domestically and the international protocols that relate to freezing orders, existent practice at other courts to show that a body of jurisprudence has grown up which is consistent, which emphasizes the seriousness of making these orders, the absolute importance of making sure that you safeguard the position of the person against whom they are made, so that what has happened to Mr. Bemba does not happen. And if it does happen, then the person who asks for those orders is obliged, very often as a prerequisite, to provide an indemnity against losses. That's how serious these orders are. And yes, there were powers in each of those tribunals to seize accused assets. It may well be that the purpose of doing that would have been different because, as you say, there was no reparations proceedings, but there was still an ability to seize money to pay fines or to repay money deemed to be the proceeds of crime. So, as it were, the purpose of seizing and freezing the money may have been different, but the mechanism was the same, and the reluctance and the care with which those courts approached it is in marked contrast, we submit, to the way in which they were sought in this case and mismanaged. And it's perhaps appropriate at this stage that I want to make something very clear to the prosecution. We don't just say that the responsibility they bear in this case is limited to one aeroplane, the prosecutor's statement, and the change in their investigative position. We say it's all down to them. They are the organ of this court that seized pre-trial Chamber 3 with the requests for assistance. It is their action which is the sine qua non to the mess that Mr. Bemba is now in. And I'm comforted in making that submission to you because the registry agree with me. They say in their filing, it's the prosecution who asked for these orders to be made, and the responsibility lies with them. Well, we're here now. The prosecution have known at least since Monday night what the registry's position is. They know full well, if they didn't before just now, what our position is. If they want to answer that, they probably ought to do so today. Now, as regards whether Article 85 has a requirement that the claimant proves malice, we disagree. I mean, I can't, there's no point in me repeating it. I disagree. I've said so. It's not in the terminology of the article itself. It's been imported by the prosecution in their filing. And in what I regard as a rather extraordinary submission, they say because there are members of their staff who are present at the Rome conferences, then they have, as it were, some sort of final word on telling you how those articles are to be construed, and I disagree with that fundamentally anyway. But I say Article 85 makes no mention of malice. It makes no mention of malfeasance. It makes no mentions of mala fides. What it does say is that you have to find a grave and manifest miscarriage of justice. I'm not here to repeat what we put in our written filing. I've been at pains to avoid doing that this morning, but we submit that this is a grave and manifest miscarriage of justice. You can see that from the language of the judges who overturned the conviction, who were very disturbed at the way in which the convicting judges in the trial chamber, as it were, dealt with issues of evidence, issues of the burden of proof. And I'm not going to go through the various quotes of Judges Morrison, Van der Weingart and Chile, who quite plainly were astounded by some of the things they read in that judgment. So I say that what Mr. Bemba has laid out satisfies the test under Article 85. It's wrong to import notions of malice or mala fides or malfeasance. But even if you do, having been challenged by the prosecution on Monday night to do so, I've done so today, and they haven't answered that either.
Merci beaucoup, Maître. Mes collègues n'ont pas de questions pour les avocats de Jean-Pierre Bemba. Alors, je vais passer à la question pour le bureau du procureur. Je laisse tomber la première question, je passe seulement à la deuxième. Si j'ai bien compris votre présentation, vous dites qu'en dehors de l'article 85 du statut de Rome, il n'y a plus de solution pour Jean-Pierre Bemba. Mais dans les écritures de la défense et dans la doctrine en général, et même si nous consultons la jurisprudence des autres tribunaux criminels internationaux, nous voyons qu'il existe quand même une compensation pour violation des droits de l'homme sur base des pouvoirs inhérents de la Cour. Est-ce que vous pensez que ça pourrait être une voie dans ce cas précis?
Thank you, Your Honors. The respectful answer to the question would be no. Under the case law from this institution, including the appeals chamber, resort to inherent powers is not necessary when there is no lacuna to be filled. And here you have, and this was all the commentators that have analyzed Article 85, and by no means the fact that some members of the prosecution team were involved in the drafting of the Rome Statute is any authority, and that one I agree completely with Mr. Haynes. You don't have to believe us. But if you look at the drafting history of the provision, if you look at the commentaries to the provision, it is clear that Article 85 is lex specialis. It is clear that the intention of the drafters was to provide for a process of a highly exceptional nature to provide compensation for wrongfully prosecuted or wrongfully convicted persons who were subsequently found through a finding of the court to have been the victims of a grave and manifest miscarriage of justice. It is a high threshold, and this was hotly debated in the institution, and attempts to water down that threshold and to create a system of more or less automatic compensation every time that there was an acquittal were rejected. So there was an explicit decision by the drafters of the statute to give this court, to give you, Your Honors, with a vehicle to provide for compensation. That is the vehicle that applies here. That vehicle is highly exceptional. But perhaps the point that where we were not clear enough was that Article 85 is a self-contained system. It applies as a system or as a means to compensate a person for wrongful decisions made by the court in relation to his or her case. It is not a vehicle to bring any type of private law claims against the court. Mr. Bemba had been given inadequate medical treatment in the detention center and suffered some injury as a result. That is not something that you bring in the context of Article 85. That is a private claim that Mr. Bemba will be bringing. It's a claim that, as I think that the registry has correctly laid out in their submissions, falls outside the jurisdiction of this chamber and falls outside the scope of Article 85. Now, I think with some of the claims, it would be good to hear our colleagues from registry as to the facts, as to how that happened, and how they see also the court responding to those private claims. Because it's surely not a process that would involve the office of the prosecutor, and it's surely not a process that would involve this chamber or that would involve Article 85, but it is a process that certainly would involve, I think, the registry. So it may be helpful to hear from them as to that particular point. I don't know whether my colleague, Ms. Narayana, wants to add something. No, I think we have replied to your question. Perhaps one tiny point, Your Honor, just for the sake of completeness. The ad hoc tribunals did have the power to issue orders aimed at the freezing of assets, and they did it once, at least in the ICTY, in the context of the Milosevic case, the 1999 decision from Judge Hunt on the indictment against Slobodan Milosevic and consequential orders. And in a very swift decision, the judge issued a request for freezing of assets, of tracing and freezing of assets belonging to Slobodan Milosevic on the basis of, I think, probably much less evidentiary foundations that the pretrial chamber had in the Bemba case. As far as I can recall, we could never find those assets at the time, and that's why there was no freezing of assets, but the power was there and it was used. Those are my submissions, Your Honor.
Merci beaucoup, Monsieur le procureur. Donc, je constate que pour vous, l'article 85 se suffit à lui-même. Et recourant, pour votre interprétation de disposition du statut, vous recourez aux travaux préparatoires et vous dites que les pouvoirs inhérents ne sont pas d'application ici. C'est bien ça.
I followed you in French, Your Honor. My French is limited, but yes, I think that is our position.
Merveilleux. Je vais me tourner vers mes collègues pour une petite consultation. Voilà. Comme je le disais au début de cette audience, normalement, nous avons deux parties aujourd'hui, hein. Les avocats de M. Jean-Pierre Bemba Gombo et le bureau du procureur. Mais il me semble qu'il y a une petite demande de la part du bureau du procureur et même du greffe de faire une petite intervention. Alors, si c'est le cas, M. Marc Le Buisson, vous avez quelques minutes pour pouvoir intervenir. Mais nous avons déjà reçu vos écritures aussi, hein, qui sont parfaites et exhaustives.
Je vous remercie, Monsieur le Président. Et le greffe comprend parfaitement que le débat, pour le moment, est sur le plan des critères légaux à remplir et qu'effectivement, donc c'est un débat entre le procureur et la défense. Effectivement, j'avais prévu effectivement de pouvoir prendre la parole. Et comme ce sera limité, je vais donc me limiter uniquement à quelques points, quelques observations d'ordre général. Tout d'abord, le greffe note l'analyse du bureau du procureur sur l'applicabilité de l'article 85 du statut de Rome et des règles 173 et 175 du règlement de procédure et de preuve, où alternativement les pouvoirs inhérents qu'aurait la Chambre pour prendre une décision sur tous les aspects de la plainte. Le greffe et le bureau du procureur, paragraphe 3 des soumissions du bureau du procureur, s'accordent sur le fait qu'une demande en compensation doit suivre une approche en deux temps. D'abord établir les conditions requises à l'article 85 et seulement ensuite considérer les montants éventuels d'indemnisation. Vis-à-vis des propos de Maître Heinz, et avec bien sûr tout le respect que je dois vis-à-vis de notre collègue, il n'y a pas de nouvelles soumissions en réponse, je veux dire, par rapport aux écritures que nous avons déposées lundi. Et bien entendu, nous ne sommes pas d'accord et nous contestons les soi-disant preuves avancées. Et nous sommes également, de ce fait, réticents à toute réplique. Vis-à-vis, par contre, des propos tenus par le procureur, le greffe est en accord avec bon nombre des soumissions du procureur. Je peux donner un complément d'information sur 4 de ces points. Mais avant de développer ces points, je pourrais faire des observations complémentaires. Donc, si vous m'y autorisez. Voilà.
Allez-y, maître.
Dans les observations du greffe, il a été démontré que le montant réclamé dans la plainte était à tout le moins exagéré ou en tout état de cause non prouvé. Le greffe clarifie d'abord que le droit de propriété de M. Bemba, qui est le droit que la défense entend faire protéger en faisant sa demande en compensation, et ce malgré aucun précédent jurisprudentiel dans ce sens, à aucun moment n'a été violé. Il ne s'est agi dans cette affaire que de mesures provisoires. Il n'a jamais été privé de son droit de propriété sur ses biens. Il pouvait continuer à administrer tous ses biens depuis le centre de détention. Le greffe, en charge de la bonne gestion du centre de détention, peut affirmer que M. Bemba avait toutes les capacités pour donner toute instruction utile pour la gestion de ses biens. Il pouvait le faire tant via ses avocats, de façon privilégiée s'il le jugeait nécessaire, que via les nombreuses visites et communications téléphoniques qui étaient libres au centre de détention. Dans le cadre du paiement de ses frais d'avocat, il a, par le passé, fait intervenir ses avocats pour que des sommes sur ses comptes soient libérées. Il pouvait, sans problème, donner toute instruction qu'il jugeait utile pour la gestion de ses biens à qui bon lui semblait. Pour 12% du montant des dommages réclamés pour détérioration de ses biens qui seraient liés à des demandes de coopération de la Cour. La défense, mais donc je ne peux pas dire la défense, Maître Heinz, que je dirais ici, n'a pas non plus démontré la responsabilité de la Cour dans la soi-disant mauvaise gestion des biens. Les dommages n'ont pas été démontrés et cette absence de preuve reste valable que la défense s'adresse à la Cour ou devant les États qui ont pris les mesures conservatoires en accord avec leur loi nationale. La charge revient à M. Bemba de prouver les dommages causés à ses biens. Il produit un rapport confidentiel, d'évaluation des dommages. Ce rapport, sans rien révéler publiquement, est basé sur des informations qui sont uniquement fournies par la défense et sont sélectives, comme le souligne le bureau du procureur, paragraphe 2 de soumission du bureau du procureur. Pour donner un exemple concret, M. Bemba ne donne aucune information sur l'état et la maintenance de ses biens avant son arrestation. Il ne donne aucun point de repère pour la Cour pour éventuellement quantifier les dommages allégués. Le seul point de repère est la date de son arrestation en 2008. Et il part du principe qu'en 2008, tous les biens qui auraient été endommagés du fait de la Cour étaient en parfait état. C'est une supposition qui n'est pas démontrée. Dans le cadre de l'identification des biens et avoirs à saisir ou geler, le fait que M. Bemba soit propriétaire ou non de certains biens n'a pas été chose facile à établir via la coopération. En effet, les titres de propriété pour certains des biens dont la dépréciation est désormais alléguée n'ont pas toujours été revendiqués par M. Bemba lui-même. Des exemples sont fournis dans les écritures confidentielles. Or, il est clair que c'est bien M. Bemba lui-même qui a la meilleure connaissance de ses propres biens. M. Bemba ne peut désormais demander d'être compensé pour des soi-disant dommages causés à des biens dont il n'a pas révélé l'existence à la Cour. Je ne vais pas prendre trop de votre temps, donc je vais directement aller sur les conclusions. Le greffe maintient que la plainte en compensation doit être rejetée car elle n'est non fondée ni en droit ni en fait. Sur les biens et avoirs dont la saisie ou le gel aurait un lien avec la Cour, lorsque la défense donne sa version sur la gestion de ces biens et avoirs, le greffe constate 1. Certains des dommages réclamés ne sont pas évalués par la défense alors que la charge de la preuve lui revient. 2. Les raisons pour l'absence de ces évaluations ne sont pas fournies. 3. En tout état de cause, la Cour, via le greffe, n'a jamais reçu d'informations ni des États ni d'autres tierces personnes permettant de conclure que les biens auraient été laissés à l'abandon. La version de la défense de Maître Heinz, ne correspond donc pas à la réalité de ce dossier qui est tout autre. La réalité de ce dossier est que le travail de coopération, on est dans le cadre de la complémentarité ici, sans révéler d'informations confidentielles, ce travail de coopération a été long, il a été difficile, car il a mis à jour, dès le stade de l'identification des biens, des problèmes complexes de droit, de propriété, de multitude de créanciers, de biens détériorés avant l'arrestation de M. Bemba. Sans rentrer dans les détails, la défense également a connaissance de beaucoup d'autres informations sur ce qui s'est passé dans ce dossier, mais ne peut les mentionner publiquement, tout comme nous, et offre de ce fait au public une version partielle de ce dossier. Donc c'est pour ça la difficulté que nous rencontrons aujourd'hui quand nous devons expliquer ce qui s'est passé, puisque la plupart des informations sont soit confidentielles, soit sous-scellées, et également expartées, parfois expartées pour le procureur et parfois expartées pour la défense.
Pour des raisons validées par la Chambre.
Oui, bien sûr. Et comme me rappelle ma collègue, et pour des raisons qui ont été validées par une chambre. Je vous remercie.
Merci beaucoup, M. Marc Dubuisson, représentant du greffier. Je ne sais pas, juste une petite consultation avec mes collègues. Voilà. Alors, je suis un peu embêté parce que après l'intervention du greffe, si je donne la parole à la défense, et puis le procureur voudra de nouveau parler, et puis ce sera sans fin. Ce que je vais faire, c'est demander à ceux qui veulent ajouter quelque chose, d'amener de nouvelles écritures éventuellement. C'est une solution qui vous satisfait?
I'd simply want to make one, possibly 2 points, which I can do in no more than 2 minutes, and it arises really from what Mr. Dubisson said and nothing else.
Okay, we are going to do that. 2 minutes for you and 2 minutes for the office of the prosecutor.
Thank you. At the risk of repeating myself, it is our case that the claim for the damage to Mr. Bemba's property does not depend upon a finding under Article 85. There is an inherent jurisdiction. Perhaps I could give you an example. Let's suppose Mr. Bemba had never been arrested. Let's suppose he had never been detained in custody. Let's suppose he appeared before this court on a warrant, on a summons. But during the process of that, his goods had been seized and the court lost or destroyed them. He would have no claim under Article 85, but he would have a claim against the court under its inherent jurisdiction for the destruction of his property. And that's precisely the way in which we say that that is a claim which stands alone. It may be that it's consequential loss under Article 85, but it is equally losses that for which he is to be compensated under the court's inherent jurisdiction. Now, I'm afraid I simply do not understand Mr. Dubisson's submissions that Mr. Bemba's rights to property have not been interfered with. We are all agreed. Pretty much everything that he had in March of 2008 has been destroyed. And yes, I agree. A good deal of what is in Mr. Dubisson's files we haven't seen. It cannot apparently be disclosed to us. But what has been disclosed is a witness statement from a bank manager, a witness statement from a director of an airline company who rented out Mr. Bemba's aeroplanes, a witness statement from a lawyer of Mr. Bemba who provides you with cogent, admissible evidence that he owned all that property and it was all destroyed. And Mr. Dubisson has had that for 2 months and has offered nothing in response to suggest that Mr. Bemba didn't own those aeroplanes and that they were not destroyed. So I don't understand that submission. It's quite wrong.
Beaucoup, Maître Heinz. Monsieur le Procureur.
Thank you, Your Honours. 1 minute wrap-up submission. This hearing has shown basically what now the claim that Mr. Bemba is bringing is about. There is, on the one hand, an Article 85.3 claim that seems to now be predicated, it didn't used to, but now seems to be predicated on mala fides by prosecutor of the court. And then there is an independent claim, which is a private claim for damages to his property. Both claims must necessarily fail. The first one, we have already provided written reasons why there is no grievous manifesta, miscarriage of justice. We can also make clear that in this here that we completely dispute the nature of the claim that the court or the prosecutor acted in mala fides. We did our job to the best of our abilities. And indeed, we push for the freezing orders, as we are required to do under the statute for the benefit of victims, and that is perfectly fine and well. And that was a proper discharge of prosecutorial functions. No reasonable claim of mala fides can be done on that basis. And then we received the ancillary claim of damages to his property. And this is where I think that basically the position that we have taken, consistent with the position of the registries, this falls manifestly outside the scope of Article 85, and it would be inappropriate and dangerous to resort to inherent powers of the chambers. This is a complex matter. It involves, as Mr. Haynes correctly recognized, it involves the court's legal personality. The possibility of bringing a case against the court raises a host of critical legal issues of public international law that, frankly, I am certainly not in a position to answer, including the court's possible assertion of immunity, including which would be the forum for such a claim. This is not something that this chamber should rule on, and I respectfully think there is no need for that. This is an Article 85 claim. You have to deal within the context of that provision, and then Mr. Bemba would be free to choose whatever forum he wishes to choose for bringing any subsequent claims that he wishes to bring. This concludes our submissions, Your Honors. Thank you for your patience.
Merci beaucoup, Monsieur le procureur. Nous tous, nous l'avons remarqué, c'est un débat très compliqué et très difficile. Et c'est pour cela que je remercie les uns et les autres d'abord pour vos écritures qui ont été très claires, et très exhaustives, mais aussi pour vos présentations qui ont été aussi très brillantes. Nous arrivons donc au terme de cette audience dans l'affaire le procureur contre Jean-Pierre Bemba Gombo. J'ai saisi donc cette occasion pour remercier tous les participants à cette audience. Je pense aux interprètes, je pense aux sténotypistes et bien entendu aux officiers et agents de sécurité. Je salue aussi notre public et à tout le monde, je dis bonne journée. L'audience est levée.
All rise.